May it please the court, my name is Bert. My co-counsel is Brian Sia, and we represent the petitioners, Maria, Elena, and Monica Quispe. Your Excellency, this is a case about the Quispe sisters, two young women from the indigenous community of Wami, Naira, who were detained by the Special Military Base, or SMB, in control of their province when they were only 12 and 15 years old. These soldiers were sent to Naira to maintain control over the area and to fight crime. But instead, for 1 month in March 1992, they took the Quispe sisters away from their homes and detained them on accusations of involvement with terrorist activities. The Quispes were never brought before any judicial authority. For 1 month, the same soldiers brutally violated the Quispes' essential human rights, first by repeatedly using them as domestic labor and then as targets for their sexual depravity. And yet, almost 3 decades after the declaration of the state of emergency, Naira has allowed these men to enjoy impunity for their actions. This, Your Excellency, is a travesty of justice. My submissions will argue the following. Number 1, Naira is in breach of the American Convention of Human Rights, or ACHR obligations, to the petitioners under Articles 5, 6, 7, 8, and 25, regarding the violations committed in 1992. Secondly, Naira's declaration of a state of emergency does not excuse the aforementioned violations. My co-counsel will argue that under Naira's general duty to ensure free and full exercise of human rights to all persons, number 1, the fact that the SMB soldiers have been protected from prosecution by the domestic limitation period is in itself a violation of both the ACHR and the Convention of Bellum do Pará, to which Naira is also a signatory. And number 2, Naira's failure to prevent and investigate the domestic abuse suffered by Maria Quispe in 2014 is also a violation under the same conventions. Moving to our first submission, Your Excellency, the thesis of our substantive point is as follows. In A, repeatedly raping and gang raping the Quispes. B, detaining the Quispes on mere suspicions of being involved in the Freedom Brigade's criminal activities. And C, forcing the Quispes to cook, clean, and do laundry at the Wami SMB. The SMB soldiers cruelly and deliberately violated the Quispes' human rights. At the material time, we want to highlight that there are 3 categories of violations, and I will be taking each category in turn. In Category A, we submit that the repeated rape and gang rape of the Quispes is a violation of the right to the freedom from torture under Article 5.2. Under Article 27.2, this right is non-derogable. Your Excellency, while Article 5 consists several gradations and embraces treatment ranging from torture to cruel, inhuman, and degrading punishment, the petitioners submit that the rape and gang rape of the Quispe constitutes torture because the repeated assaults were, number 1, intentional acts, number 2, caused the Quispes to suffer severe physical and mental suffering, and number 3, were committed with the purpose of intimidating, punishing, and interrogating the Quispes, whom the soldiers believed were accomplices to the terrorist group, the Freedom Brigades.
Okay, before we get there, right, can you just show me some proof that the rapes actually happened? Because I was under the impression that at least there is contradictory evidence on that point.
Oh, well, Your Excellency, regarding your inquiry as to prove that the rapes happened, the evidence that we are relying on as the petitioners' counsel would be their testimony, as well as the other testimony that Kila Pura has found supporting this evidence. While we concede that there is some counter evidence in the sense that the state of Wami, the Wamian authorities, as well as people of the Wami community have come out in opposition of the Quispes' allegations, we would like to direct the court's attention to Article 36 of this court's Rules of Procedure, which states that in its response to in the state's response to a commission's inquiries, any allegations that are not specifically argued against are considered conceded by the state. Therefore, considering Naira chose not to provide any responsive information in its official answer to the Commission's petition on 10th August 2016. This court should consider that there is no evidence that these rapes did not occur.
Okay, so 10 August. Can you lead me to the paragraph where the state responded?
Yes, Your Excellency. If you could just give me some time to locate it.
Sure. Okay, no, it's fine. Actually, I see. Paragraph 40, right? So what the state said was that it denies responsibility for the alleged human rights violations. So you are saying that because it denies responsibility for human rights violations generally, is not specific enough to, as a procedural matter, to suggest that the rapes did not happen and that the state therefore is barred from leading any evidence on that front. Is that your position?
Well, Your Excellency, I believe the state's position with regards to the criminal complaint that Kilapura filed was that it was out of time due to the lapse of more than 15 years since 1992. So we read the state's denying its responsibility as denying its responsibility specifically regarding its responsibility to prosecute these soldiers for the alleged acts. In fact, we would even go as far as to say that the state's agreement in principle to bring a truth commission to investigate the inquiries, as well as its agreement to include the Kispe's in the, I believe, the ZTP, the Zero Tolerance Policy on Gender-Based Violence, is in itself also evidence of its acknowledgement that these acts likely occurred.
As in, the whole point of a truth commission is to find the truth, right? It cannot be that by setting up a truth commission, the truth is admitted already. Okay. So, your primary case is essentially that rather than that there is sufficient evidence, but merely that, sorry, let me clarify. Instead of saying that there is sufficient evidence, your primary position is that paragraph 40 indicates that the state failed to deny and therefore procedurally the evidence is assumed to be sufficient, something along those lines, right?
Oh, well, Your Excellency, we would like to clarify that the petition's position is actually a combination of the two. Firstly, that we do have sufficient evidence that these rapes occurred, but in addition to this, the state also has not explicitly adduced any evidence that they did not occur.
So on the evidence that is actually available, right, I think the Truth Commission point is probably stretching things a bit. So other than the Truth Commission point, why is it that based on the evidence that is currently available, at least on the balance of probabilities, it's more likely that the rapes actually occurred?
Well, Your Excellency, just a quick point of clarification regarding the balance of probability standard. We would first submit that the balance of probability standard isn't the standard that is binding on this court. Per this court in Velasquez-Rodriguez, the Inter-American Court has the freedom to determine the amount or the quantum of the evidence necessary for deciding an issue. So this follows the civil law tradition that we do see in Latin America, where judges are adjudicating according to their inner conviction, which is a strictly personal matter. This is the case of Coas, Fernandez, and Honduras at paragraph 9.
So wait. So the standard of evidence that I have to adopt, you are suggesting is based on my internal conviction. So if I'm internally convinced that the rapes occurred, regardless of how little evidence there is, then that is the end of things. And the contrary is true. If I'm internally not convinced that the rapes occurred, then for the purpose of these proceedings, they didn't occur regardless of how much evidence there is. Is that the point of your clarification?
Well, yes, Your Excellency. As an appointed and esteemed member of this court, your conviction is what really matters in this case. But going on to addressing the specific concerns regarding the evidence, Your Excellency, we would suggest that on the facts, it is much more likely than not that these rapes did occur. Bearing in mind that Naira is an indigenous community, bearing in mind the amount of backlash that the Kispe sisters have gotten just for bringing these allegations up, we would submit it's extremely unlikely that they would be lying about something so traumatic and something as brutal as rape.
Okay, let's move on from here then. Going back to your torture arguments.
Yes, Your Excellency.
Okay, actually, you have 3 points, right? I think purpose is the contentious one, right? So why don't you take me through that point? So what is the purpose here in relation to the rapes?
Well, Your Excellency, we believe that in this case, considering question number 42 in the clarifications, which puts out that the sisters were actually detained on allegations that they were involved in the Freedom Brigade's activities, we would submit that the purpose of the torture in this case was to intimidate and punish them for this alleged involvement. This also accords with this constant trend that we've seen where rape is often cruelly used by state agents as a way to intimidate, demean, and subjugate women suspected of anti-state activities. We've seen this in Espinosa Gonzalez in Peru, we've seen this in Rosendo Cantu in Mexico, and we believe that this is another such instance, Your Excellency.
What if they are just raping for the sake of raping instead of trying to obtain any information? After all, it's false accusations, right? They could have just apprehended them because they were interested in raping them. Does that change your case?
Well, Your Excellency, regarding the hypothetical that these soldiers in question were, and I quote, raping for the sake of raping, we would submit that in this case, considering they were still SMB soldiers and still agents of the state, it would be considered a case where the purpose of the rape would be to intimidate these women or to punish these women for being indigenous and for being for being a community that was involved in the Freedom Brigade, being from a community that the Freedom Brigade was targeting.
As in, my problem with your case is that rapes happen all the time without any specific purpose beyond the rape itself. And the inferences you are drawing from the facts that they were to obtain particular information or to punish them for being from a specific minority, they are not impossible, but there's no additional information such that it makes it likely that that is the case. For instance, is it suggested that this particular group of soldiers, the SAM, were prejudiced, against the minority in question? And even then, right, it just seems to me that if you are looking at inherent likelihood of things and situations of war, right? So, comfort women issues and all that, to terrorize the population, it may be a purpose, but it need not be. Do you understand my concern? Like, it seems to me that there is something more immediate and obviously problematic than torture, and is more appropriate to go under whatever it is than to treat raping as torture with a specific purpose.
Well, Your Excellency, we understand your concern with regards to the definition of purpose and what would really fulfill the limb. But we believe that the ACHR's definition of torture, which is adopted from the Inter-American Convention to prevent and punish torture, is instructive on this issue, which define torture, define the purpose element as being for the purposes of criminal investigation, intimidation, personal punishment, preventive measure as a penalty, or for any other purpose. And especially the last limb should be taken into consideration because it evinces that this court has a very wide notion of what would constitute purpose. So we would believe that in the inquiry between what would simply constitute cruel, inhuman, degrading punishment versus something that would constitute torture, we believe that it's a question with regarding the last element. It's really a question of something that could be attributable to the state, especially if we consider the fact that all the purposes that have been laid out by the ICPPT are elements or are activities that inherently have a state connection to it.
As in, sorry, I don't get your point. So, so what is the relevant state connection here?
Well, we would believe the relevant state connection is the fact that the SMB soldiers were state agents and were ostensibly there to restore order in the region. And therefore, we think that the natural inference that follows that natural inference that follows their objective would be that any activity that they take is coloured by the element of being for.
So you are saying that they were raping on behalf of the state, lah?
Well, I wouldn't use those words expressly, Your Excellency, but I would say that the fact that they were state agents and the fact that they were conducting these heinous activities should be sufficient to find torture.
Okay. Let's move on for now.
And even if Your Excellency is not with us in this conclusion, we would submit that the abuse of the key space of that intensity would minimally constitute cruel, inhuman, or degrading punishment that would still be a violation of Article 5.2. Moving then to Category B, the petitioners submit that the detention of the key space without allowing them the opportunity to appear before competent judicial authority is a violation of a litany of rights, Articles 7.3, 7.5, 8.1, 8.2, and 25.1, which we set out in our written memo. But for the purposes of today's proceedings, I will be focusing on the contentious allegations, which is that the detention of the key space for the entirety of March 1992, without first bringing them before a judicial authority, is a violation of their right to trial within reasonable time under 7.5 and 8.1. As a preliminary point, we note that both Articles 7.5 and 8.1 protect the same liberties, but differ into their references as to what constitutes a reasonable period. This was set out by this court in Jorge Jimenez. This distinction, Your Excellency, stems from the fact that Article 7.5 applies specifically to accused persons subject to pre-trial incarceration, which is already unequivocally an infringement of a right to one's personal liberty. Accordingly, in order to minimize this violation, states are obligated under the ACHR to give procedural priority to persons subject to pre-trial incarceration. The Article 7.5 measure for what constitutes a reasonable period therefore imposes this obligation on the state to resolve the case on a priority basis and avoid any delays compared to Article 8.1. Necessarily, a violation of Article 7.5 should necessarily be a violation of 8.1 as well. Your Excellency, looking at the law concerning assessing the reasonableness of this length of incarceration, it is first submitted that the 1 month period was unreasonable, considering it was clear that the key space were not involved in terrorist activities and therefore would not have hindered any investigation into the Freedom Brigades and would not have absconded or evaded justice. A precautionary detention was therefore entirely unnecessary. Notably, the state of Naira has failed to produce any concrete evidence that proves that the key space were targeted for any real terrorist involvement, and the petitioners would go as far as to say that it was unlikely that the SMB soldiers really believed the key space posed a significant threat. Firstly, they were 12 and 15-year-old children with no known links to the Freedom Brigades and no incentive to assist the terrorist group that was attacking their own province. Secondly, empirical evidence suggests that an overwhelming majority of terrorists tend to be male rather than female. And most significantly, Your Excellency, the behavior of the soldiers indicates that they never saw the key space as a significant threat. Instead of interrogating the sisters, all they did in detention was force them to clean, to do laundry, and to cook for the base. We will go as far as to say that this behavior is entirely inconsistent with how any law enforcement individual would treat a terrorist suspect. Our position, therefore, is that the SMB never had any concrete evidence of the link between the Freedom Brigades and the key space, let alone evidence of a risk that the key space would hinder the judicial investigation or attempt to escape justice.
I agree, but what has that got to do with being brought promptly before a judge? You're saying that they were arrested in bad faith in the first place, but that does not seem to fall neatly within 7.5 or 8.1, right? Because they seem, 7.5 at least seems to control the amount of time before the person appears before the judge, as opposed to whether or not there were any legitimate grounds for arrest in the first place. Am I right to say that?
Yes, Your Excellency. And just to clarify our position again, our argument simply is this. 7.5 puts forward that a pretrial detention is possible, according to Jorge Jimenez, only when the state's findings show that there was a relevant and sufficient criteria that would justify a preventive detention. So our first argument in response to that is there was clearly no criteria that would justify a preventive detention because there was no risk that they would hinder the investigation or there was no risk that they would attempt to escape justice.
Okay.
However, Your Excellency, even taking the case at the highest, that there was evidence of involvement and evidence that would justify a preventive detention, the duration of this detention clearly evinces that Naira failed to process the criminal proceedings with due diligence and with promptness. While this definition of diligence has not been articulated under any of the human rights treaties, the UN Human Rights Committee has indicated that the detention period must not exceed a few days, and a judicial review ideally should be made available within 48 hours. This narrow definition of what constitutes diligence is also echoed by the European Court of Human Rights jurisprudence. The European Court has found that even in cases of emergencies that threaten the life of the nation, there should not be an interval greater than 7 days between detention and appearance before a judicial authority, as anything longer impairs the essence of the detainee's rights to free movement and a presumption of innocence. It is our position that this court should therefore find that in light of this state practice, 1 month is a manifestly excessive period of detention, especially since there is no clear reason for Naira's delay, since the Kispe's case appears not to be particularly complex. Accordingly, Your Excellency, we submit that Naira has violated the Kispe's rights under Articles 7.5 and 8.1 of the ACHR. I see I'm running out of time, so if there's no other matters of which I can be of assistance to, that concludes my case.
Okay. You have one additional part, right, about the cooking and cleaning?
Yeah.
Okay.
You enter your password to stop the video.
Okay. Do you have a summarized version of that? Why don't I just hear it 2 minutes?
Okay. Thank you, Your Excellency. Finally, in Category C, forcing the Kispe's to cook, clean, and do laundry was a violation of their freedom from slavery. This is Article 6 of the ACHR. Under Article 27.2, this is also a non-derogable right. Our position is that this is a clear case of slavery in that it was a case where involuntary work was exacted under the means of penalty. While Article 6 acknowledges that Article 6.2 doesn't prohibit the imposition of a penalty, with regards to work or service normally required for a person in prison in execution of a sentence or a formal decision, we would like to point out that the Kispe's were not sentenced, they had never seen a competent judicial authority, and the Article 6.2 caveat clearly refers to cases where there has already been a sentence that's being processed. And this also accords with Article 7.5's particular concern with the rights of a person who has yet to be sentenced and is still entitled to the presumption of innocence. Yeah, that's my summary.
Okay. Yeah, that seems straightforward. Okay. Let's talk about it first. Because in any event, you are not doing rebuttals, right?
Yeah.
So, yeah, there's no need for you to do resistance.